And Disney is trying to dismiss a wrongful death lawsuit citing a free trial of its streaming service. Jeffrey Piccolo's wife died in February because of an allergic reaction while eating at a restaurant in Disney World. The family says they told their waiter multiple times about her allergies and were reassured about being accommodated. Now, Disney argues because Piccolo signed up for a free trial of the Disney Plus agreement back in 2019, under those terms and conditions, he cannot bring the case to court and must settle by arbitration. Oh, to help us break this all down, let's bring in Misty Marris, trial attorney and legal analyst. Misty, the reason we love you here is because sometimes things seem so black and white, cut and dry, that we're like, well, of course this makes sense, but you always have a way to make it clear for us. Have you ever heard of a legal strategy like this? And do you think the argument from Disney is a winning one?
This is really something. So when's the last time you read the terms and conditions when you signed up for any of your apps? I know me, I scroll right through and say, okay. But listen, let's break down what's actually happening here. So what Disney is arguing is that any and all claims, no matter what they are subject to this arbitration agreement that was written into those terms and conditions on the Disney Plus app. Now, the argument is pretty novel, maybe a clever defense argument. The reason they want to do it is arbitration is a more favorable defense venue, especially when you have a very sad case like this where jurors, their heartstrings could be really torn by this case. So get it before an arbitrator, you've got a judge who's going to look at the legal nuances. But Nick, you can't look at this language in isolation. You have to look at the rest of the terms and conditions and say, would this apply under this circumstance? And if you look at it, it's everything you would expect. It's about membership. It's about canceling. It's about copyright. Nothing to do with stepping foot in the park. So at the end of the day, Disney is trying to expand the reach of this arbitration agreement to when you're in that park and you're going to the restaurants or you're going on the rides. But I think this is going to fall flat, and we're going to see the plaintiffs successfully litigate this case in a court before a judge and jury as opposed to an arbitration.
And Misty, Disney is also saying that, hold up, that restaurant is not owned or operated by Disney and that they're defending themselves from being named in the lawsuit. How does Disney fit into this lawsuit?
Right, so that's another issue. So the first question, threshold, who's going to hear the case? Is it an arbitrator or is it a judge and jury? That will be decided shortly. That's the argument they made to try and compel arbitration. The second issue is their liability. Disney is saying they're not an owner of the restaurant. That is a defense to say they don't have direction and control over the restaurant and therefore cannot be held liable for this death. The questions of fact to be answered that will come out throughout the trial: what control does Disney have? Do they do training? Do they have safety protocols and procedures? Presumably, even if the restaurant is owned by somebody else, there is some sort of agreement to operate on Disney property. So those are all factual questions that need to be answered in order to know whether or not Disney can be held liable, whether they're an owner of the restaurant or not.
Misty, we love when you come on the show. See, I hope to never need your services, but if I do, Misty, I want you in my corner. Misty Marris, thank you so much.
See you, yes.
Misty, thank you so much. All right.